Now back to the show. This is AM 650's The Law Show.
Welcome back to the program. Nice to have you with us. We have guests in studio talking family law from Lindsay Kenny LLP in Vancouver, and they have offices in Langley as well, and both offices are represented on this morning's panel. Angela Thiel and Christine Eilers are with the Vancouver offices of Lindsay Kenny, downtown at 401 West Georgia, and Puneet Kara is with the Langley office of Lindsay Kenny, and I do not have the address memorized.
And
Where are you?
I have it. It's Suite 400, 8621 201 Street. So it's 86 and 201 Street intersection.
Okay.
Just around the highway.
All right. Yeah. Excellent. Thank you for that. I feel much better already. Let's talk a little bit about procedures. We're talking about going to court here, family law matters, friends. And once we've talked about the fact that in British Columbia you can initiate an action in either Supreme Court or provincial court. So let's assume that for whatever reason we've initiated an action. And Christine, we'll start with you on this one. Once that action has been done, an action is what? I go and I file suit or lay claim? What is the nature of the action?
You file what's called your pleadings, which are basically your initiating document which sets out all your claims. So if you're claiming for guardianship of the children or for a certain parenting schedule, you'll put that in there. If you want spousal support, you put that in there. If you want all the assets to be divided, you put that in there. And it's sort of a general overview of what you're eventually asking the court to do. So you file your pleadings, and then the opposing party files their responding pleadings. And if there's anything they want, then they file a counterclaim. And that's the first step. That's how the action is basically started.
Both parties involved in this family law dispute must file these initial bits of paperwork, correct?
Well, you have to file it to start an action.
Right.
Sometimes.
So, but it's the other person I'm thinking of. I've got my paperwork. I am mad. I am focused.
Yeah.
Here's my pleadings. Go for it. Rubber stamp that. I'm in. But the other person may not be so cooperative.
Right. Well, I mean, it's not like a civil matter where you're suing over a debt and you file your pleadings and you sue or you serve the opposing party with your pleadings and then they just never respond.
Exactly, yeah.
And then you go in and you get yourself a default order, which is basically they didn't respond. I by default get my judgment.
Right.
A family law matter is not like that. So, you have to follow up. You have to try and deal with it. Even if the person doesn't necessarily file a responding pleading, you can still negotiate and go to court even and do other things, and that does actually often happen in family law.
Okay, so Puneet, let's assume that both parties are behaving somewhat in adult fashion and have done the required basic paperwork. Both the pleadings, both cases have been filed. What happens next?
In terms of a journal next step, once the pleadings are done with, we have something called case conference, which is available both in the provincial and the Supreme Court. And the best way to describe is what Angela said, is a non-adversarial hearing with a judge. I actually like to prefer it calling like a kitchen table conference with a judge, where the judge is sitting, you're sitting with your lawyer if you have a lawyer.
Right.
The other side is sitting with his lawyer, and you talk about what the issues are on the file and see if you can resolve this with the perspective from a judge, sometimes, which is very helpful for the parties to move forward from the initial hitch position. Also, something very important about the case conference is before you have a case conference, you are obligated to file what's called a financial statement.
Okay.
So
your first filing is the pleadings. This is what I want. This is the basis of my case. And then so the court is going to require that I submit a full disclosure of all my financials? Is that part of the deal?
Absolutely.
Well, if finances are an issue.
Oh, okay.
If you just happen to be going in there because you want to talk about your parenting schedule and support isn't an issue, but almost no case that you're not going to have a financial issue attached to where the kid's going to live. So you're going to need financial disclosure.
Angela, I got to tell you, I find this whole notion of a non-adversarial hearing in a divorce proceeding kind of funny, if you don't. Only because we know that in a lot of these cases there's some pretty worked up grown-ups involved here, and they're feeling pretty adversarial. Even though the lawyers are going, well, look, calm down. The judge will be there. We'll all sit around the table quietly and behave ourselves and keep our tongues in our head and get this thing done. But some of these hearings have got to be still pretty intense.
The ones with lawyers are usually pretty well managed. I've gone into a JCC, which is a Supreme Court hearing, one particular day, and we got through it very quickly, and the judge kind of looked down at me and she said, I haven't done JCCs before. She said, I had 3 in a row of self-represented litigants, and they were really terrible. And I guess I'd like to ask you, Ms. Steele, because your experience, are these working? And I said, absolutely, Judge. Yeah. I mean, I know you got to deal with the self-reps, but absolutely they're working, because a lot of things can get resolved at those hearings. Because what the judge is saying to you is, if you don't resolve it to this particular issue today, you're just going to have to go to court on an interim application, and that's going to be more costly. And I can tell you, if I was a judge hearing that, I'd probably decide something like this.
Oh. So the judge gives you at least a clue or two as to how this thing might go.
They're often different. That is one approach a lot of judges take, which can be really helpful. Another thing they often do is basically mediate the dispute. So you kind of get a free mediator for, an hour and a half or whatever it's set for, which can be really helpful. But hearing their perspective is invaluable.
And a JCC, what does JCC stand for?
A Judicial Case Conference.
Okay, and that's obligatory procedure in any of these family disputes.
There's one in provincial court, one in Supreme Court. They just have slightly different initials.
Okay.
Yeah, it's called a Family Case Conference in provincial and Judicial Case Conference in a Supreme. And one thing to add to that is you cannot bring applications or the interim relief applications prior to going through this mandatory process. So, you have to take that plunge. You need to face the other side, sit down on the table and bring the issues up at least once to try and resolve this before you say, okay, I have to go in front of a judge and let the judge decide.
Right. And what, Christine, what's the usual outcome in terms of percentages? And I know this is hard for you to do, but sort of ballpark it for me. From these judicial conferences in which the parties are basically, they are compelled to sit down with a judge and get a sober hour and a half of law. What percentage of that results in an outcome that doesn't end up in a trial?
Definitely a lot of them can resolve completely at that stage, or you can at least get all the issues on the table and clarified to the extent that, you go back to the office with your lawyer and you sort of know what your position's going to be, and you can settle it quickly after that fact too. So a lot of them do settle entirely there. There's other things that can settle, like smaller issues. For instance, you'll agree that child support will be paid in this amount,
right,
pending trial or final resolution, or you'll agree that this is going to be the parenting schedule for the kids until we, decide later. And oftentimes the orders that are put in place at the JCC wind up being the orders that
stand
stay
all the
in
way
place.
through.
Yeah.
Interesting.
So, you might not think you're resolving it all there, but maybe you are.
Okay. Angela, this is a term that in Canadian law we hear a fair bit, although I frankly don't know how many of us know what it means. It's discovery. What is discovery in the trial process? We're in family law. We've got two people whose relationship is going south, and they've filed all their paperwork. They've had the conference with the judge, the JCC, and then there's something on the list that's discovery. What is discovery?
The simple explanation is it is a pre-trial questioning of the other side in the litigation, and it can only be used against you. So if
Does it take place in front of a judge?
No, it takes place with a court reporter and a transcript is provided.
Okay.
So, for example, if you and you often kind of use it, even so some of the questions are not necessarily a question that you would ask in court. But one of the other reasons it's used for is it's just giving a person a taste of what it's like to being questioned by a lawyer in a more civilized process. That's just a court reporter up there. It can be used very effectively to, if someone really wants to go to court, I will often be fairly rough on them in discovery just to say, well, I'm not going to treat you very well in trial.
Right.
But it also can be used for your client who's maybe being stubborn, to hear what they sound like. Discovery is also intimidating. There's somebody going...
I can certainly imagine it to be. Yeah, absolutely.
And you kind of get away in discovery with asking questions that you wouldn't ask in trial. And so if I'm going to do a discovery, I generally am doing it on a case that I want to beat somebody up, so they really don't want to go to trial.
Is this a mandatory process, Christine? Before you go to trial, is this discovery an essential step in the pre-court appearance thing?
No, it's not. It's
Oh,
something
okay.
that you may or may not choose to do depending on the file.
Oh, okay.
I mean, the purposes Angela's talking about are important, but there's also, the more traditional function, which is sort of to find out information, to find out what the other party is going to say at trial, and to challenge them on information they may have disclosed, and find what you're going to hear at trial.
So you want some of the other team's playbook before you actually go to trial, and that's what discovery provides you.
Well, that too, but I mean, often, you've got a financial disclosure, you've got that financial statement, but now it's 6 months later,
Okay.
and you're trying to sort of update, and there's things that aren't covered, like, well, when you sold, now you've got this house. Now, when you sold that previous house, where did all the money go? Because you can't really tell from the documents. Sorry, we forgot the part about you also have to disclose a bunch of documents before discovery.
Right.
So
all those financials, all the rest of it, right?
So someone may give you a document, and you're looking at it on their list, and you're looking at it in the book and thinking, what are they giving me this document for? What's it trying to prove? And at discovery, you'll say, well, I noticed I got this document, it was a check written to Joan Blogs. Can you tell me about that check? And they say, oh yes, that was me paying off her previous debt to her sister. And, you may not have heard about that before. And sometimes people put in useless documents that they want to use to embarrass your client that have absolutely no legal relevance. Better to find that out at discovery and make sure they're not showing up at trial to waste everybody's time.
We're talking going to court here, family law being the basis of the issue that will get you to court, and what happens along the way. And when we come back after this quick timeout, we'll find out about, well, the day in court. And I get the feeling it's going to take more than a day in a lot of these cases. Our guests from Lindsay Kenny, LLP, in studio are Angela Thiel, Christine Eilers, and Puneet Kara. And we'll be back with more in just a couple of minutes.
There's more of the show still ahead. This is AM 650's The Law Show.